Good morning, everyone. For those of you who don't know me, I'm Jo Henderson. I'm a partner in the employment team at Myerson. Thank you for joining us this morning for our spring update. Thank you to those who've joined us in the office for breakfast, and thank you also to those who are joining us online. So welcome. Before we start, just a few housekeeping points. If you hear a fire alarm, that's not a drill. We're not expecting one this morning, so please follow me and my colleagues to the assembly point on the car park. If you need a comfort break, please use the door at the rear of the room and our reception staff will help you with whatever you need. In terms of timing, we'll talk for about an hour this morning. Because we've got quite a lot to get through, if there are questions as we go along, could you please hold on to those and we'll deal with those questions at the end of the session. And if you joined us online, please feel free to put your questions into the chat function and we'll make sure that we pick those questions up after the webinar this morning. I'm joined this morning by my colleagues, Charlotte Gilbert. She is a partner in the employment team also and head of Myerson HR, our retained service. Also joined by Vicki Fagan, who's an associate in the team and a specialist in employment law and working families. In terms of what we need to get through this morning, obviously there's a lot going on in the employment law arena at the moment, not least because of the government's plan to make work pay initiative. We saw the Employment Rights Bill published in October last year. And in March, we saw certain changes made to the bill. There's also several government consultations out there about proposed changes. Many of the proposed changes are in principle with regulations to follow, providing all of the detail. And so there's a lot that we don't know at this stage. The most impactful changes are likely to happen in autumn 2026, which is obviously quite some time off, and there's plenty of time between now and then for additional proposals, and also for some of the proposals to be watered down, as we've seen already, for example, in relation to the right to disconnect and to some extent in relation to collective redundancies. It's not possible this morning to go through all of the updates and all of the changes in the hour that we've got. So in line with our usual approach, we've picked the top 10 things that we think you need to know this spring. So look into our agenda. I'm going to pick up the first 3 topics on the agenda relating to discrimination issues. Vicki's going to pick up the middle section around working families, and Charlotte's going to round up with some important points about the Employment Rights Bill, and in particular the changes that we have seen made during March. Because we've got a lot to get through, I will make a start. The first topic I'm going to look at is religion or belief discrimination. And the reason for that is because of an important recent decision in the Court of Appeal that will be binding on all tribunals and the Employment Appeal Tribunal. Just a quick recap on the law. So having a religion or belief is a protected characteristic under the Equality Act. So if an employee is dismissed or if a worker suffers a detriment because of their religion or belief, then that would amount to unlawful direct discrimination. It's important to note, though, that UK courts and employment tribunals must interpret the Equality Act in line with the European Convention on Human Rights. Just looking at the European Convention, for our purposes this morning, the relevant parts are the Article 9 of the Convention, which provides a right for freedom of religion and a right to manifest that religion. Article 10, the freedom of expression, freedom of speech. However, those fundamental rights are qualified rights, and that means that they can be interfered with or restricted where that is justified. The Convention also provides that the exercise of any right must not be aimed at the destruction of somebody else's fundamental rights, for example, the right to family life or the right not to be discriminated against. The recent decision in the Court of Appeal has provided us with some clarification around those difficult cases where different fundamental rights need to be balanced. The The case is Higgs and Farmor's school, and so the facts are that Mrs. Higgs was a pastoral administrator at Farmor's school. What she did was to repost some Facebook posts. So the original posts included homophobic and transphobic comments, which were offensive, relating to same-sex relationships, gender fluidity, and about the fact that these were being discussed as norms in sex education in schools. She reposted that post saying, "Please read this, they are brainwashing our children." As a consequence of that, and a consequence of a complaint by a parent, she was summarily dismissed. And the reasons given for her dismissal were breach of the school's code of conduct, discrimination, and potential risk to the school's reputation. Mrs. Higgs then raised a claim in the Employment Tribunal for direct discrimination on the grounds that she had been dismissed because of her beliefs. Her beliefs were Christian beliefs. She believed that same-sex relationships and same-sex marriage were contrary to biblical teachings, that she did not believe in gender fluidity, and she opposed the teaching of those issues being norms in sex education in primary schools. There was no dispute that those were protected beliefs. They were genuinely held, and they related to substantial aspects of human life. And there was no dispute either that the reason for her dismissal was the way in which she had expressed those beliefs through the Facebook post. What the Court of Appeal has helpfully done is to clarify that there are two types of dismissal that employers need to think about in these circumstances. Where there is a dismissal just because of the mere fact that a belief has been expressed, but the employer or a third party finds that objectionable, that will be an unlawful dismissal and discrimination. The second category relates to a dismissal because of the way in which that belief is manifested or stated, and where that is objectionable. In that case, the dismissal will only be lawful if the employer can show that it is proportionate to interfere with those fundamental rights to manifest religion and the freedom of expression. There is a third category, and that's perhaps where the conduct of the employee has resulted in dismissal, but it's not possible for the employee to say that it's a manifestation of their religion because the conduct is not closely connected with their beliefs. So in this case, the Court of Appeal ruled that Mrs. Higgs' dismissal was unquestionably a disproportionate response. And the reasons for that were that her posts were objectionable, but they were not grossly offensive. The words that were offensive were not her words, but were not her original words, but were just included in something which she had reposted. There was no evidence that her conduct would damage the reputation of the school. There was no evidence that her beliefs would impact on her performance of her role. And the employer had open to it alternatives, for example, issuing a statement to reassure parents or colleagues. An interesting point was also that Mrs. Higgs didn't seem to have the insight into what she had done and failed to remove the posts from Facebook. And the Court of Appeal held that that was permissible, given that her beliefs were deeply held. So, as a result of this case, we think it is going to be more difficult to dismiss employees or to discipline employees for the way in which they manifest their beliefs, even where the employer or third parties find that belief objectionable. What's necessary is for the employer's response to that conduct to be both reasonable and proportionate. And the Court of Appeal has issued some helpful guidance in these reputational type cases. And that is that employers need to look at the subject matter of the statement made and whether it is relevant to the employer's business. The employer needs to objectively look at the content of the statement and not what a person's perception or understanding of that statement might be. The employer will also need to look at how the belief has been expressed. And the interesting point here is that the threshold before it is offensive is very high. Objectionable is not enough. It has to also be offensive. And an employer will also need to consider whether the statement made is the personal view of the individual making the statement, or whether it's the view of somebody else which has been restated. And the seniority of the person involved might be relevant to that assessment. So in a case like this, what's going to be important is for employers to carefully analyse what has actually been said and how it has been said. And care needs to be given to the reasons given for any action or sanction taken by the employer. In this case, the employer had talked about discrimination and damage to the school's reputation, and there wasn't any evidence to back that up at all, and so their response was disproportionate. And finally, employers must look at whether what action they are taking is necessary, or whether there is some other less discriminatory way for dealing with the employee's challenging conduct. I'm going to go to my second topic, and that's the prevention of sexual harassment. We talked about this new duty for employers in some detail at our last seminar in the autumn, because the law had then been enforced for about a week. So this is the anticipatory duty for employers to take reasonable steps to prevent workplace sexual harassment. And so unusually, that's a proactive and positive duty on employers to prevent harassment before it starts. And we've talked previously about the need for risk assessment, appropriate policies, education and training, appropriate channels to raise complaints, systems for monitoring and addressing trends in the workplace. I think the point to make today is that this is not a one-off exercise. We are continuing to help clients with risk assessments and training, and there are resources out there to assist, but it's a continuing obligation that needs to be revisited on a regular basis. In terms of enforcement, there are two routes for enforcement. The first is for individuals to make claims of sexual harassment in the workplace. And where those claims are made and an employment tribunal finds that an employer failed in its duty to prevent harassment, then the employment tribunal can uplift the compensation payable to the individual, depending on the extent to which the employer has failed in its duty. The second route to enforcement is through the Equality and Human Rights Commission, and the scope for enforcement there is wider. The Commission takes a view that sexual harassment can happen in the workplace at the hands of not just colleagues, but also third parties, so customers and suppliers and the public. And so it has a wider outlook on compliance with the duty. And secondly, regulatory enforcement is also possible where there has been no actual harassment or any claim or complaint of harassment. So the Commission may take a view that an employer is failing in its duty and then take enforcement action. The Commission's powers are quite wide-ranging. They can conduct investigations into workplaces. They can seek agreements with employers around how they're going to address problems in the workplace and agree with them action plans. And they can also intervene in litigation. Because of the delays that we're seeing in cases coming to the employment tribunal and the even longer period of time that it takes to get cases to the appellate courts, we're unlikely to get any guidance from the tribunals about what reasonable steps might include. It's helpful, however, that the Commission has already taken enforcement action in this area, and this gives us some insight into what reasonable steps an employer might take. So the first action taken by the Commission was in November 2024 against the Welsh Rugby Union. That followed an investigation by the BBC finding that the workplace culture was poor and that individuals were at risk of harassment. And so the Commission agreed with the union various actions that it must take in order to address that problem. I won't go through the whole list because some of it is the more obvious stuff around training and education. But there was an interesting action point to review the use of NDAs, so that's non-disclosure agreements or confidentiality agreements. And there was also an action point for the union to put in place an equality, diversity and inclusion strategy across the business with a 5-year plan, and that senior executives were to have individual performance objectives included to make sure that that plan was reached. So that was quite a strong requirement from the Commission. More recently, just last month, we've seen further action from the Commission in relation to McDonald's restaurants. Again, there was a BBC report in January this year highlighting that there remained problems in relation to workplace culture at McDonald's restaurants. The Commission had previously entered into an agreement with McDonald's Restaurants Limited in 2023, but the limitation of that was that most McDonald's restaurants are actually franchises and the agreement didn't cover those businesses. So the Commission has written to all franchisees just on the 14th of March, I think, explaining to them what reasonable steps they must take to make sure that they comply with the duty to make reasonable steps to prevent workplace harassment. They included communicating a zero tolerance approach, regular, and I think the important word there is regular, harassment risk assessments, safeguarding younger and vulnerable employees, having in place effective, sensitive complaint handling procedures, actively monitoring the workplace and employee engagement, and ensuring that vulnerable workers were comfortable in raising complaints. I think what this highlights in particular is that the steps that are to be taken to prevent harassment in the workplace must be specific to the type of business that you are dealing with. So this is very much targeted at the type of employee that might work at McDonald's who might be vulnerable or who might be young. So for me, tracking what the Commission is doing is likely to give us a real insight into what reasonable steps employers might be required to take to comply with the duty to prevent harassment. Staying with harassment, I'm going to turn to my final topic, which is harassment and the Employment Rights Bill. And sticking with the topic of prevention of sexual harassment in the workplace, there are 2 amendments in the bill relevant to this. The first is that there will be, going back, the current law was in relation to the duty to prevent harassment was introduced by the Conservative government, and the Labour government doesn't think it goes quite far enough. So the change to the employment bill is not that employers must take reasonable steps to prevent harassment, but that employers must take all reasonable steps to prevent harassment. So there's a shift up, a slightly more robust approach. The bill also provides for regulations to explain what all reasonable steps might include. There will be a consultation about what those steps might include, and it's very likely that the government will collaborate with the Equality and Human Rights Commission to develop those regulations, and that's why I mentioned the importance of what they have to say about their expectations from employers. The other change in the Employment Rights Bill is that to the extent it's not already clear, the Equality Act, to the extent it's not already clear, those who raise issues around sexual harassment or support complaints of sexual harassment will have whistleblower status, and so they will be have that added layer of protection. My last slide relating to the Employment Rights Bill is in relation to third-party harassment. So the original version of the Equality Act made employers liable for the harassment of workers by third parties. That was repealed by the government in 2013. The Labour government will bring that liability back into the legislation with a little more bite. In this version of the Equality Act, a single act of harassment may render an employer liable for that harassment. And in this case, harassment relates to harassment on the grounds of any protected characteristic, not just sexual harassment. Excuse me. Liability will not attach to the employer, again, where the employer has taken all reasonable steps to prevent that harassment. And so there is a theme there and a consistency. And again, we'll perhaps be looking to the Commission to find out what those reasonable steps are. Remembering, of course, that where you may be liable for the acts of third parties, the risk assessments that employers will need to take will be considerably wider than the current obligation just to look at harassment within the workplace. With that, I'm going to hand over to Vicki, who's going to pick up our working families issues.
Good morning, everyone. I'm going to take you through the next 4 topics. So I'm going to cover the new right to take neonatal care leave and pay, proposals in relation to other family-friendly rights, a case update in relation to dismissal both during and following maternity leave, and a case update regarding protected conversations. Diving into the first topic, I'm going to provide you with a bit of an update on the new right to take neonatal care leave and pay. And as a mum of 2 little ones who spent the first 2 weeks in neonatal care, this is something that's really close to my heart. So I just want to give you a little bit of a background first as to where we get to with this new law. The explanatory memorandum to this law indicates that around 40,000 babies spend over 1 week in neonatal care each year. And when you can see the statutory paternity leave is only 2 weeks, parents, fathers and partners may have already exhausted the leave before the baby's even discharged. And even if you spend time in neonatal with your baby like I did, it's a really worrying and stressful time. And actually you're spending time on maternity leave that would have already otherwise been at home, recovering and looking after your baby and spending time with loved ones. In 2019, there was a survey undertaken by Bliss, and that's the charity for premature and sick babies. And it was found that 36% of fathers and partners whose babies had been in neonatal care for 4 weeks or more had actually taken sick leave. And 11% of parents had actually had to leave their job. So it was recognised that support was needed for those people in those situations. And back in March 2020, the previous Conservative government confirmed that it would bring forward legislation to govern that change. This was initially thought to be brought in by the Employment Rights Bill, but actually in July 2022, the government confirmed that they were supporting a private member's bill. And we now have the Neonatal Care Leave and Pay Act 2023. And that received royal assent on the 24th of May 2023. And with many of these types of law, regulations are needed to be brought in to give effect to the law. And these regulations come into effect on the 6th of April this year. The development really does send a signal and a message to employees and employers of the importance and value of recognising this stressful period and providing adequate support to parents in such circumstances. It's envisaged that around 34,000 parents will take up paid neonatal care leave every year. So certainly something that employers will need to be aware of. That being said, the regulations are quite complex and they do take quite a bit of getting to grips with. So I'm just going to give you a bit of a whistle-stop tour with this today. Starting with the right to take the leave then, this is applicable to children born on or after the 6th of April this year. It is a day one right and it's applicable to employees only. And to be eligible, the employee must have a qualifying parental or other personal relationship with the child. It also applies in adoption cases, including from overseas, and in surrogacy cases. The right only applies where a child spends a qualifying week in neonatal care. And the definition of neonatal care is actually really quite wide. I've detailed it on the slide in full here for you, but you can see it includes hospitals, it includes outpatient treatment, it includes palliative or end-of-life care. The qualifying neonatal care must begin within 28 days of the child's birth and lasts for a continuous period of at least 7 days. And that doesn't include the day in which the care actually starts. The right itself is to take 1 week of neonatal care leave for each qualifying week the child spends in neonatal care, and that's up to a maximum of 12 weeks. In the case of multiple births from the same pregnancy, so twins in my case, the maximum is still 12 weeks. The leave must also be taken in blocks of a week. There are some really quite technical points regarding when the leave can be taken, and you might hear this as it develops as Tier 1 and Tier 2 leave. But generally speaking, the leave can be taken from the day after the qualifying period and must be taken within 68 weeks of the child's birth. The entitlement to neonatal care leave is in addition to other statutory rights. So if the employee has taken a period of maternity leave, then this right will be added on to the end of that leave. There are notification requirements which can be waived between the employer and the employee. And these, again, very much vary depending on whether the leave is to be taken within the Tier 2 or Tier 1 frame. Employees on neonatal care leave are entitled to benefit from all of the terms and conditions that they would have otherwise enjoyed had they not been on the leave, except for pay, which we'll come on to shortly. And in most cases, the employee will be required to return to work into the job that they enjoyed prior to the leave. But if the neonatal care leave is taken consecutively with a period of parental leave for more than 4 weeks, or where they take other statutory leave that totals 26 weeks, the right is to return to the same job, or where it's not reasonably practicable, another job which is both suitable and appropriate in the circumstances. It will be illegal with all other family-friendly rights to subject the employee to a detriment or to dismiss the employee because they have taken or sought to take the leave. And employees who are taking neonatal care leave or have recently returned from such leave have the right to an enhanced redundancy protection. So they have the right to be offered a suitable alternative role in priority of other employees who are at risk of redundancy. Moving on to the pay. If you qualify for the leave, you also qualify for the pay, except for 2 exceptions. So you have to have 26 weeks of continuous employment that ends with the relevant week, which is the 15th week before the expected week of childbirth. And you also have to have received normal weekly earnings for a period of 8 weeks ending with the relevant week of not less than the lower earnings limit. And in your packs, you've got some rates in there that will detail the lower earnings limit there for you. There are also notification requirements, which rather confusingly are slightly different than the notification requirements for the leave. But in practice, employers will usually require these to all be in writing. The amount of the pay is expected to be the same as other family-friendly leave rights. And so from the 6th of April this year, that will be £187.18 per week, or 90% of earnings if lower. And again, the pay is for a maximum of 12 weeks. I do appreciate that that is a whistle-stop tour of the rights, and there might be more detailed considerations that crop up in practice, and you might need to go and take some advice. But I think the main takeaway is that employers need to be aware of the rights. They need to ensure that HR and managers are trained appropriately, dealing with requests sensitively, and ensuring that employees are not subjected to any sort of detriment. Employers might also find having a policy to be a really helpful starting point, as this can give guidance to both managers and to the employees. Moving on to the next topic then, we're going to look at some future developments in relation to other family-friendly entitlements. And for those of you who attended our last seminar, I touched on some of the family-friendly rights that have been proposed by way of the Employment Rights Bill. I've detailed those on the slide there for you, but it's the right to make paternity leave and parental leave a day one right, making it unlawful to dismiss an employee who has been pregnant within 6 months of their return to work, introducing a new right for bereavement leave, and making it harder for an employer to refuse a flexible working request. All of those proposals are still continuing within the Employment Rights Bill, but due to the necessary regulations and the consultations that will be needed to give rise to these, they aren't expected to come into force until 2026, as Jo mentioned. That being said, on the 5th of March this year, some amendments were made to the Employment Rights Bill, and I'm just going to briefly mention the one that's particularly relevant to family-friendly entitlements, as well as a reminder about the bereaved partner's paternity leave. It's gone a bit quiet on that front recently, so just want to remind you of that. The relevant amendment to the Employment Rights Bill relates to bereavement leave and pay for pre-24-week pregnancy loss. As some of you may already know, the bill already contains provisions to convert the existing right to statutory parental bereavement leave to a more general form of bereavement leave. However, as currently drafted, that would not apply in the event of pregnancy loss before 24 weeks. In January 2025, the Women and Equalities Committee recommended the extension of parental bereavement leave and pay to those who experience pre-24-week pregnancy loss. And amendments have now been made to the bill to make those who have suffered a pregnancy loss due to miscarriage, ectopic pregnancy, molar pregnancy, medical termination, or unsuccessful IVF embryo transfer to 2 weeks bereavement leave and statutory bereavement pay. I also want to flag the Bereaved Partners Paternity Act, which actually was passed as law back in May 2024. It provides employees the day one right to take paternity leave where the mother or adopter dies. It ensures that where both the mother and the child die, the bereaved partner would still be able to take the leave. And it allows for the bereaved partner to take kit days without the leave coming to an end. The Act also keeps open the possibility for regulations regarding additional protection during a redundancy situation, both during the leave and after. And while the initial focus was very much on making paternity leave a day one right, there is also a plan to increase paternity leave for bereaved partners from the usual 2 weeks to 52 weeks. Now, the Act itself doesn't actually implement those changes, but those could be brought in by way of regulations. Similarly, the right here is only in relation to leave and not pay, but that might also be something that we see come in through regulations. Unfortunately, despite the initial suggestion that this right would come in to force in April of this year, the regulations are still very much awaited. So while we're awaiting those, the specific details are still out there. In reality, the Act will only affect a small number of employees, since the majority of employers will actually offer paid leave to bereaved partners in this event in any sense. But it is important for us employers to be aware of the direction of travel here, given it will impose minimum entitlements. Moving on to my next topic then, I just want to give you a case update following an employment appeal tribunal decision in relation to the rights under Regulation 10 of the Maternity and Parental Leave Regulations 1999. And just by way of a reminder, Regulation 10 provides that if in a redundancy situation during a protected period, so I've detailed the protected period on the slide there for you, if during that time there's a redundancy situation and it's not practicable by reason of redundancy for the employer to continue to employ someone under their existing contract, the employee is entitled to be offered a suitable alternative vacancy, where there is one, over and above other employees who are at risk of redundancy. If the employer doesn't comply with that requirement, then the employee will have a claim for automatic unfair dismissal. Now, that's relatively straightforward where perhaps the whole team is at risk of redundancy and where there's a new role that's being created as part of maybe a new restructure. In that case, if that new role is a suitable alternative, then a pregnant employee would have the right to be offered that new role without having to go through a competitive interview process. The situation, however, can be a little bit more confused where an employer is reducing the number of existing roles. And that was exactly the situation in the case of Carnival plc and Hunter. By way of background, Mrs. Hunter was one of 21 team leaders across the business. And on the 6th of April 2020, she went on maternity leave. On the 29th of April 2020, the company announced that they were making redundancies as a result of the COVID-19 pandemic. And they were going to reduce the number of team leader posts from 21 to 16. Following a scoring exercise, Mrs. Hunter was one of the 5 team leaders who were subsequently made redundant. And she brought a claim for automatic unfair dismissal, claiming that the company had breached Regulation 10 by not offering her one of the remaining team leader posts. And in the first instance, the Employment Tribunal agreed. Carnival plc then appealed against this finding, and the Employment Appeal Tribunal has actually allowed the appeal. The EAT has provided some guidance here, so they have confirmed that where an employer is simply reducing the number of existing roles, there is no requirement to offer one of those remaining roles as a suitable alternative vacancy. This is because each of those roles pre-existed, and they could not have constituted a suitable alternative vacancy. Regulation 10 is not engaged until the process of selection of the people who would remain in the reduced number of generic roles is known. The EAT held that in a conventional redundancy, in which there is simply a reduction of existing roles, Regulation 10 does not override a valid selection process, requiring in effect a person eligible for Regulation 10 protection but who scored lower than others to be bumped into the role over and above someone that would score higher. The finding of automatic unfair dismissal was squashed, and the matter has been remitted to the tribunal for a brand new hearing. Moving on to my final topic, I'm just going to cover a reminder of what a protected conversation is and a case update demonstrating when an employer's actions may be deemed improper, and that can render the protected conversation admissible in tribunal proceedings. As a reminder then, a protected conversation gives an employer the ability to have an off-the-record conversation with an employee without there being a pre-existing dispute to a proposal leading to the employment being terminated. An employer in these circumstances have the comfort of knowing that if the negotiations break down and the employee subsequently brings an unfair dismissal claim, then the contents of that protected conversation remain confidential and cannot be referred to in tribunal proceedings. For conversations to remain protected and to retain their confidentiality and inadmissibility in the employment tribunal, there must not be any sort of improper behaviour in the settlement discussions. And the ACAS Code of Practice on Settlement Agreements provides a non-exhaustive list of examples of improper behaviour, which I've detailed in full on the slide here for you. But you can see that includes bullying or intimidation. It includes discrimination. It includes putting undue pressure on a party by not giving them reasonable time for consideration, which as per the guide is 10 calendar days, or by perhaps the employer saying that before any form of disciplinary process has begun, that if the settlement proposal is rejected, then the employee will be dismissed. An Employment Appeals Tribunal has considered further whether an employer's behaviour during a protected conversation was improper in the recent case of Gallagher and McKinnon's Auto and Tyres Limited. By way of a little bit of background, Mr. Gallagher was employed by McKinnon's as a branch manager for almost 5 years. Following his absence due to illness, McKinnon's considered that they could continue without a branch manager. And Mr. Gallagher was invited to a meeting, which was described as off the record, where he was offered an exit package and a payment of £10,000. 2 directors were present at that meeting, and one explained that if Mr. Gallagher accepted a package, a settlement agreement would be signed. But if he rejected, there would be a redundancy process. Mr. Gallagher was given 48 hours to consider the offer, and then text messages were exchanged to provide a breakdown of the £10,000. Mr. Gallagher did not accept the proposal within 48 hours and was then invited to a formal meeting to discuss his potential redundancy and the possibility of suitable alternative vacancies. Mr. Gallagher was subsequently made redundant and he brought a claim for unfair dismissal. To support his claim, he sought to rely on the employer's actions during the meeting. He said that he'd attended to discuss his return to work, that the director had told him that that wouldn't happen. He said that the director had been aggressive and had been forceful. The Employment Tribunal, in the first instance, found that the decision was a protected conversation under Section 111A of the Employment Rights Act and was therefore inadmissible. The tribunal acknowledged that there is an exception to the admissibility rules where there is improper behaviour, but they didn't feel that that was the case here. In particular, they found that the tribunal found that the meeting had been conducted without aggression and without raised voices. Mr. Gallagher appealed to the Employment Appeals Tribunal, arguing that there had been improper behaviour, where he had been told that his role was redundant and that the dismissal would take place if he did not accept the proposal. He also argued that the meeting had been set up under false pretences and that its surprise element, along with the fact that he'd only been given 48 hours to respond, had put undue pressure on him. The EAT dismissed the appeal, but in doing so, they analysed the company's actions. And it's this that I think is helpful in the circumstances. So in respect of the company telling him that a redundancy process would begin if he did not accept the offer, the EAT considered that this was not the same as telling him he was going to be dismissed. During a redundancy consultation, there is an obligation to consider ways to avoid the redundancy, including considering any suitable alternative roles. And so it did not inevitably mean that starting the redundancy process would have actually resulted in him being dismissed. In respect of the allegation that he'd been invited to the meeting under false pretences, there was no finding that the company had acted deliberately in a misrepresented way or had lied about the purpose of the meeting. It was acknowledged that an employee ought to be given notice of the type of meeting that they were attending in order to minimise the element of surprise. And it might not be fair to use a return to work meeting as a discussion as a pretext for those settlement discussions, but in that case, it wasn't itself improper. It was noted that Mr. Gallagher had been provided with a breakdown of the figure offered, that the meeting had been conducted calmly, and that he'd had time to discuss matters with his family. All of those factors had had a bearing on the nature and the extent of the pressure that had been placed upon him, and it was found that the company had mitigated the initial shock of the meeting. And finally, in respect of the time frame to indicate acceptance, it was noted that the 48 hours related to whether Mr. Gallagher would accept the verbal offer. If he had accepted, then a written offer would follow, and he would have been able to have more time to take advice on the written offer. It was concluded that the suggested minimum 10 calendar days was relevant in consideration to the written offer only. It was, however, noted that another judge might have reached a different conclusion, but in this case, having regard to all of the circumstances, the initial 48-hour deadline to accept the verbal offer did not amount to undue pressure. This case, I think, serves as a helpful reminder to employers in preparation for having the off-the-record conversations with employees. Employers need to consider whether a protected conversation or indeed a without prejudice discussion might be more appropriate. Employers need to be mindful that any inappropriate or improper behaviour during such discussions may lead to them being brought up in subsequent tribunal proceedings if a deal is not done. And employers need to ensure that the alternative, whether that be a redundancy, a capability process, or a disciplinary, have not already been predetermined. Employers should ensure that the employee has sufficient time to consider and take proper legal advice, as well as making it clear who the employee is permitted to discuss the matter with. And that brings me to the end of my topics. I'm going to hand over to Charlotte for the final slides.
Okay, I'm home straight now. So there have been some significant changes to the rules on collective redundancies since the amendments to the Employment Rights Bill came out in March. So I'm going to take you through those in this next section. So as a quick reminder then, the current law on collective redundancies is that where an employer is proposing to make redundancies of 20 or more at one establishment within a period of 90 days or less, it must consult with elected representatives of those employees and also notify the Secretary of State using a Form HR1. And it's a criminal offence not to do this, and the penalty is an unlimited fine. Consultation must be in good time and be at least 30 days before the first dismissal, and that's where between 20 and 100 dismissals are proposed, or be for 45 days where 100 or more dismissals are proposed. An establishment for the purposes of this test means the local unit or entity to which affected employees are assigned to carry out their duties. Now, the original version of the Employment Rights Bill intended to remove the words "at one establishment" altogether, which would have meant that collective consultation had to be carried out when 20 or more redundancies were proposed across the whole company and not just in one location. So this would obviously have had a very significant impact on large multi-site employers. However, the latest version of the bill keeps the establishment test in, but it also adds an additional threshold test to the legislation. So under the amended bill, collective redundancy consultation will be required if the employer proposes 20 or more redundancies at one establishment, which is the current test we have, or when at least the threshold number of employees is met, and that's across the whole of the employing entity, regardless of location. That's still within a period of 90 days or less, but there's currently no number for this new threshold test. But it's understood that it won't be less than 20, and it'll likely be a number between 20 and 100, or it could be a percentage test, such as the lower of 100 or 10% of the employees across the company. The length of the required consultation periods will remain the same at 30 and 45 days. Now, the amended bill also states that in carrying out collective consultation, the employer does not need to consult all employee representatives together or try to reach the same agreement with all of the representatives. So that's a helpful clarification for employers, and this addresses concerns raised by many that the bill would require reps to be physically brought together and consulted as a central group, as opposed to in their respective locations. There's also a change to the compensation that can be claimed by each employee when an employer fails to comply with the regulations, and that's known as the protective award claim. Now, at the moment, the protective award is a claim for up to 90 days gross pay per employee. The amended bill will double the maximum protective award, taking it to 180 days gross pay. And this has been written into the bill after a consultation on strengthening penalties on employers. But it's worth noting that the government's original plan to introduce an uncapped award and to allow interim relief have now been dropped. So timing-wise then, we don't yet know when any of these changes will be coming in, and the government still need to define the new threshold test in the accompanying regulations, and they still need to produce the promised guidance around this for employers. So it's looking likely that the changes will come into force sometime in 2026. So obviously it's something for us all to bear in mind, or for employers to bear in mind, certainly in terms of any major restructuring proposals. So the practical impact then on employers of all of these changes taken together is quite considerable. Despite the new threshold test being not less than 20 redundancies, the end result will mean that the regulations are triggered by small numbers of redundancies across different sites. And so more collective redundancy exercises will have to be carried out and increased numbers will be affected. For multi-site employers, a single proposed redundancy at one site could actually end up as part of a collective exercise, meaning small redundancies could be delayed and would need an appropriate representative. and that's even if it's a unique role and it's unconnected to any other redundancies. Larger employers will need to implement a comprehensive way of keeping track of any proposed redundancies across all of their sites. And non-compliance will obviously be a lot more expensive for employers, with the protective award being doubled. And it's worth remembering that the current position is that the 90-day period requires employers to look forward and backward in counting the numbers of redundancies and working out whether this triggers collective consultation. Now, the bill hasn't actually clarified what will happen when the new threshold test comes in and whether this will require employers to carry out collective consultation with an earlier or ongoing batch of redundancies, or whether there is a plan for this. We'll just have to wait and see what happens when the regulations come out and when the new threshold is actually defined. Okay, so we went through the changes in relation to 0 hours contracts in our autumn seminar, but there have been a few updates since then, mainly in relation to extending rights to agency workers. So I'm just going to take you through the key updates on that here. So just to recap then, the use of 0 hours contracts has long been criticised as a means of abusing low-income workers and providing no job security or guaranteed hours. And back in 2015, the use of exclusivity terms in 0 hours contracts was actually banned altogether. We then had the King's Speech, where the government stated its intention to ban exploitative 0 hours contracts completely. And since then, we've had the Employment Rights Bill, which hasn't followed through on this ban, but it's instead recognised that 0 hours contracts can suit both employers and employees due to their flexibility. However, the changes in the bill are intended to address this problem of one-sided flexibility. And they've mainly done that by including a duty on employers to provide guaranteed hours, amongst some other rights and protections. Now, the original draft of the bill gave detailed provisions in respect of 0 hours contracts and those with a low number of guaranteed hours. And in the amendments to the bill, which came out last month in March, this has now been extended to agency workers as well. So this is to close any possible loophole which would have encouraged companies to move to an agency worker contract in order to avoid the new duty to provide these guaranteed hours. Now, the provisions were already very complex, and extending protections to agency workers does add further complication. And that's because they're not engaged directly by the business. It's obviously a tripartite relationship, and their contracts with the agency, but the services are ultimately provided to an end user or client. Now, the government's recognised that 0 hours arrangements and agency workers do need to be treated differently, but its priority here is to provide all workers with greater job security. So the provisions on the guaranteed hours regime are complex, and a lot of the key details are yet to be confirmed in the regulations. But the main points to be aware of are that the bill requires employers to offer guaranteed hours, which reflect the hours that qualifying workers and agency workers are actually regularly working over a defined reference period. Now, it's not yet clear what reflect means or how this should be calculated, and we don't yet know the reference period until it's all set out in the regulations. But from the consultations, it seems likely that this reference period will be a 12-week period. Now, the responsibility for offering guaranteed hours is on the employer, and in relation to agency workers, it will fall on the end user or client. And that's obviously because they are best placed to forecast and manage the flow of future work, as opposed to the agency who places them there. There will be further details in the regulations as to what the working pattern or the days must be offered, and we're also awaiting clarity as to what prescribed form the offer should be made in and how long the response period should be. But the latest bill amendments suggest that the response period should be no less than 1 week. Now, if the agency worker rejects the offer, the previous arrangements continue as they were, But the guaranteed hours regime means that the end client is still obliged to keep making offers at the end of each subsequent review period. And that's to ensure that these properly reflect the hours actually being worked. If they accept it, then the agency worker and the end client will enter into a direct contract together. And that won't automatically end their contract with the agency. They might want to still continue working through the agency for different clients, or they might give notice under that contract. But it's important to note here that once the offer is accepted, those guaranteed hours become a permanent term. And so the employer or the end client is required to provide that level of work and to pay them for it. So there's no scope to unilaterally reduce the number of guaranteed hours, and that's even if the work dries up. So there'd potentially just have to be a redundancy process in that situation. But there is still a need to undertake subsequent review periods where more hours start to be worked, or if the contract falls below the minimum number of low hours, which is yet to be defined in the regulations. So obviously these provisions place a lot of extra burden on employers and end clients, but the good news is that there are some limited exceptions. Firstly, the bill provides that the offer can be a fixed term, which is referred to as a limited term contract in the bill, but that's only where it would be reasonable. So this might include where the worker is needed for a specific task and the contract provides that this will be terminated when the task is performed, or where the worker is only needed until the occurrence of an event or on a temporary work need, such as providing cover for another worker. The suggestion is that there'd be no need to make an offer of guaranteed hours if a limited term contract has ended because of a specified event. But it's really all quite broad at this stage, and the question of what would be reasonable is yet to be clarified. Secondly, there won't be any need to make an offer of guaranteed hours where the worker's fairly dismissed or resigns during the reference period or before the offer's made. And also if there's a resignation or dismissal during the response period, that will be treated as withdrawn. There may also be further circumstances when an offer can be treated as withdrawn and some further exceptions to the duty to have to make this offer when the regulations come out, so one to watch out for. But finally, another key change which was added last month is that the duty to offer guaranteed hours could be disapplied by the terms of a collective agreement. So there is some comfort for employers here with the option to contract out of the guaranteed hours regime, and that's provided that the collective agreement is incorporated into the individual's contract. It's always important to be aware of the risks and penalties, and so any worker who's not offered these guaranteed hours on these terms can bring an employment tribunal claim. And also, where an employer avoids the regulations through manipulation of hours or work patterns during that reference period, then again, a tribunal claim can be brought. The maximum award for these claims will be set out in the regulations, so this is still awaited. Now, obviously, the majority of these changes are not expected to take effect until 2026, so there isn't a need to take any immediate action, especially since we don't yet have the regulations. But there might be some practical preparations which businesses may want to consider now, and that's auditing the current workforce just to identify how many people are engaged on 0-hour or low-hour contracts, as well as the numbers of agency workers. Reviewing those hours and considering how a 12-week average calculation might impact those workers. And it's also worth tracking seasonal fluctuations in the company's demand for work. And that's just to get a better understanding of when this is likely to be an issue and to gather evidence to try and support the need for a limited term contract. Okay, final section. So this is a topic which hasn't changed in the latest amendments, but it is something that we always get asked about. And so I think it's helpful just to recap on where we are currently at with day one unfair dismissal rights. So the Employment Rights Bill abolishes the 2-year qualifying period, making unfair dismissal a day one right, which is obviously going to be a significant change. Now, it's not coming into force until autumn 2026, and the regulations are still awaited, and that will obviously clarify how this will all work in practice. But in terms of what we know so far, The bill introduces the concept of an initial period of employment, during which a modified version of the right to unfair dismissal will apply. The duration of this initial period isn't specified in the bill. That's something that needs clarifying in the regulations. But the government has stated a preference for a 9-month period. Now, during this period, it's suggested that a light touch procedure will apply, but the specifics of this procedure and what steps will have to be taken are yet to be determined, and this will be done through consultation later this year. We know that the standard of reasonableness for dismissals during the initial period of employment will be modified, and it will require employers to show that the reason for dismissal is related to the employee, including for conduct, capability, or some other substantial reason. But it's important to note here that redundancy hasn't been included in this list of fair reasons. So that presumably means that the usual process would need to be followed from day one, and that the right not to be unfairly dismissed would therefore apply to redundancy dismissals during the initial period. Now, it's been commented that the reason for this is because the fair reasons during the initial period need to specifically relate to the employee, and a redundancy is excluded as being a business reason. Although it's important to note that the bill makes clear that the 2 years service is still required in order to claim a statutory redundancy payment. Also worth noting that the end of a fixed term contract is excluded from this list for the light touch procedure during that initial period. So that will be another scenario for employers to have to undertake a full process in the same way that's required now, where they have 2 years continuous service. And compensation for unfair dismissal during this initial period of employment is expected to be lower, but this remains subject to consultation as well. So in terms of any steps we can be thinking about now, really it's still a bit too unclear and a bit early at this stage to be making any preparations, particularly as there's still so much we don't know. But if you are wanting to have a think now, it might be worth considering your pre-employment screening processes and how your current probationary periods are managed. Ultimately, being vigilant at the outset of the contract and in those first 9 months of employment will be key. And so perhaps getting managers used to this now, particularly in monitoring performance during probationary periods, might just assist in terms of implementing that new light touch procedure in future. And it might help change some mindsets from feeling reliant on the fact that the first 2 years of employment has always effectively been a long probationary period. Now, even though most probationary periods in contracts tend to be 3 to 6 months, I would say there isn't really any point in changing anything at this stage, because from what we understand, the initial period of employment, which is likely to be 9 months, will just apply anyway. It will just be more important than ever to properly assess the employee's performance and conduct in this time, and obviously follow whatever procedure ends up coming out in the regulations. But there is the option to get involved in the consultation process, and you might want to consider this if you're a large employer with a high turnover of staff in the first 2 years, and if this is going to cause major problems for your business model. But ultimately, it's definitely coming in next year. It's just a question of how this light touch procedure will work, amongst other things, and what processes and training will need to be put in place to manage this when we all know more. Okay, so that brings us to the end of our spring update for today. But before I move on to questions, I just wanted to mention Myerson HR, which is our fixed fee retainer service. And it's basically unlimited advice from our team of 12 here at Myerson on a day-to-day HR employment law queries. It also includes access to our portal of template documents, guides and policies, and we undertake an audit of your existing policies to bring you up to date. The fixed fees tailored to the size and needs of your business, and a lot of our clients find this very reassuring and a very cost-effective way of having access to unlimited support from our team. So if you'd like to know more, or you would like us to quote for providing Myerson HR, then please do contact me or anyone else in the team. We'd be very happy to help. And you can also go to our website and get ask for a quote through the Myerson HR inquiry page. Okay, so thank you to everybody for listening today. For those of you in the room, we'll move on to questions, but for those watching online, you can submit questions to us, which we will review and respond to shortly. But for now, we'll say goodbye and end our live recording.